Let's first define what is law. It is the science of moral law founded on the rational nature of man that governs his free activity for the realization of individual and social ends of life under an aspect of mutual conditional dependence. It is also defined as a rule of conduct, just, and obligatory promulgated by legitimate authority and common observance and benefit. It is a rule of action or any system of uniformity. It determines not only the activities of men as rational beings, but also the movement or motions of all objects of creation, whether animate or inanimate. What are the characteristics of law? It is a rule of conduct, it is an obligatory, it is promulgated by legitimate authority, and it is common observance. There is a Republic Act about tourism, a Republic Act 9593, an act declaring a national policy for tourism as an engine of investment, employment, growth, and national development, and is strengthening the Department of Tourism and its attached agencies to effectively and efficiently implement that policy, and appropriating funds therefore. What is tourism law? Tourism laws refer to a combination of state, federal, and international laws that regulate various aspects and functions of the travel industry. I learned that political law is an established legal practice area encompassing the intersection of politics and law. Political law comprises election law, voting rights law, campaign finance law, laws governing lobbying and lobbyists, open government laws, legislative and executive branch ethics codes, legislative procedures, administrative procedures, constitutional law, and legislative and regulatory drafting. I also learned that the tourism promotion sector has the primary function of promoting the Philippines as a tourist destination domestically and internationally. It devises integrated marketing and promotional activities such as information dissemination, public relations, special events, and related tourism programs. And lastly, the role of local government is to promote the social, economic, environmental, and cultural well-being of their communities, and their involvement in tourism must be related to that.
I am number 35 Mika, and today I will discuss about the difference of special law and general law. General law, a law that is unlimited in time, applies throughout the entire territory subject to the power of legislature that created it, and applies to all persons of the same class is referred to as general law. It refers to a country's territorial legislations. It is made up of all people, things, activities, and events that occur in a country's territory and are governed by it. Example of general law: a citizen's responsibility for paying taxes, following rules of the road while driving, and using business license are examples of what is covered by general law. Special law. A special law is one that applies to a specific subject or to a specific individual or members of a group of people or things. A special law refers to legal principles that courts will not automatically recognize and implement, but that must be demonstrated and brought to the attentions of the courts by the parties seeking their recognitions. Example of special law. Philippine criminal laws include the revised penal code, Crimes punished under special penal laws include money, laundering, and illegal possession of firearms. No criminal intent is needed in order to find a person liable for special penal law. Punish crimes as long as the act is committed, then it is a crime.
Hi everyone, today we are going to discuss about the three branches of the government. The Philippines is a republic with a presidential form of government, wherein power is equally divided among its three branches: the executive, legislative, and judicial. The government seeks to act in the best interest of its citizens through this system of check and balance. The executive branch. The executive branch is headed by the president, who functions as both the head of state and the head of government. The president is also the commander-in-chief of the armed force of the Philippines. The president is elected by popular vote to a term of 6 years. The president then appoints his or her cabinet members whom he or she presides over. The executive seat of government is administered officially from Malacanang Palace. Also, the official residence of the president in Manila. The president may no longer run for re-election unless he or she becomes president through constitutional succession and has served for no more than 4 years as president. Legislative branch. The remainder of the House seats are designated for sectoral representatives elected at large through a complex party list system, hinging on the party receiving at least 2% or 6% of national vote total. The upper house is located in Pasay City, while the lower house is located in Quezon City. The district and sectoral representatives are elected with a term of 3 years. They can be re-elected, but they are no longer eligible to run for a fourth consecutive term. The senators are elected to a term of 6 years. They can be re-elected, but they are no longer eligible to run for a third consecutive term. The House of Representatives may opt to pass a resolution for a vacancy of legislative seat that will fade away for special election. The winner of the special election will serve the unfinished term of the previous district representative. This will be considered as one elective term. The same rule applies in Senate, however, it only applies if the seat is vacant before a regular legislative election. The last one is the judiciary branch. The judiciary branch of the government is headed by the Supreme Court, which has a Chief Justice as its head and 14 associate justices, all appointed by the President on the recommendation of the Judicial and Bar Council. Other types of courts of varying jurisdiction around the archipelago are the lower collegiate courts, regular courts, and Muslim courts. In lower collegiate courts has Court of Appeals, Court of Tax Appeals, and Sandigang Bayan, while the regular courts has regional trial courts, metropolitan trial courts, municipal trial courts in cities, municipal circuit trial courts. The last one is Muslim courts, Sharia district courts, Sharia circuit courts.
What is political law? Political law is an established legal practice area encompassing the intersection of politics and law. Political law comprises election law, voting rights law, campaign finance laws, laws governing lobbying and lobbyists, open government laws, legislative and executive branch ethics codes, legislative procedures. Political laws are applied primarily to government officials, candidates, advocacy groups, lobbyists, businesses, non-profit organizations, and trade unions. Campaigns for federal office are subject to contribution limits and certain contributions are prohibited. The Department of Justice Public Integrity Section has jurisdiction involving alleged criminal violations of many political laws. At the state level, most states have administrative agencies to enforce law with respect to campaign finance and ethics rules. Political law is that branch of public law which deals with the organizations and operations of the governmental organs of the state and defines the relations of the states with the inhabitants of its territory.
Constitution or codes of rules which aspire to regulate the allocation of functions, powers, and duties among the various agencies and offices of the government, and defines the relationship between these and the public. The Constitution may be a single document, and it may be also some rules, maxims, and conventions. Why we have a Constitution? Even the best Constitution cannot pave a road or build a sewer, it cannot manage a clinic or administer a vaccine. It cannot educate a child or take care of an elderly person. Despite this obvious limitation, constitutionalism is one of the crowning achievements of human civilization. Countries that have succeeded in establishing and maintaining constitutional government have usually been at the forefront of the scientific and technological progress, economic power, cultural development, and human well-being. This helps in maintaining discipline in the society, makes government responsible, and makes people aware that the government belongs to them. It is important to keep in mind that the term constitutional state theoretically differs from the constitutional democracy, as it does on practice, any form of government together with electorate may establish a constitution.
Let me tell you a little bit information regarding our national territory. The Philippines is an archipelago in Southeast Asia that consists of 7,641 islands with a total area of 300,000 square kilometers. It is located between South China Sea in the west and the Philippine Sea in the east. It is divided into three main groups, islands such as Luzon, Visayas, and Mindanao. The two largest islands here in the Philippines are, first is Luzon, second is Mindanao. It is comprised of 65% of the country's total landmass. National territory comprises the Philippine archipelago with all the islands and water embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains, including the territorial sea, the seabed, the subsoil, and other submarine areas. The waters around, between, and connecting the island of archipelago, regardless of their breadth and dimension, form part of the internal waters of the Philippines. How political law significance to tourism? It is in a way that our territory are divided of several islands that is connected to our archipelago. To determine the national territory of the Philippines, we have law inside and outside of our national territory. We will be able to know if the tourists came outside from our archipelago. That is what we call inbound tourism. If the tourists going outside of our archipelago, that is what we call outbound tourism. If the tourists tour within our archipelago, that is what we call local or domestic tourism. Therefore, we will be able to know if the tourist is local or foreign tourist.
Labor. The body of law applied to such matters as employment, remuneration, conditions of work, trade unions, and industrial relations. In its most comprehensive sense, the term includes social security and disability insurance as well. They create the framework for employers in constructing their recruitment and selection processes, as well as the way they run their human resources departments in retaining and promoting employees.
Hi, I'm Princess. So today we will be talking about what is labor law, or what we all know as the Labor Code of the Philippines. So Labor Code of the Philippines is stand as the law governing employment practices and labor relations in the Philippines. The decree that was enacted on May 1, 1974 by the late President Ferdinand Marcos was the Presidential Decree number 442. It is a decree that is instituting a labor code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on social justice. Prescribes the rules of hiring and termination of private employees, the condition of work including maximum work hours and overtime, that was written in Article 83 and 87 of the Philippine Labor Code,
in which the normal hours of work of any employee shall not exceed 8 hours a day. Any work that exceeds 8 hours is considered overtime work. This is legal provided that the employee is paid for the overtime work.
The employee's benefits, such as holiday pay, 13th month pay, and retirement pay, that was written in Article 93 and 94 of the Philippine Labor Code. It is also written in Presidential Decree number 851.
As for the Article 93 and 94 of the Philippine Labor Code, it states that a worker shall be paid his regular daily wage during regular holidays, whether or not the employee goes to work. The employer can require an employee to work on any holiday, but the employee must be paid an amount double his regular wage. And according to Presidential Decree number 851, an employer is mandated by the law to give his employees 13th month pay. The 13th month pay is required by the law should not be less than the 1/12 of the total basic salary earned by the employee within a calendar year.
And also the guidelines of organization and membership of labor unions, as well as in collective bargaining.
Now let's talk about the importance of Labor Code.
The Labor Code of the Philippines is designed to empower as well as protect employees. The Labor Code ensures that employer-employee relations are monitored, allowing both parties to be held accountable for their actions. There is a natural hierarchy between the employer and the employee. However, the Labor Code helps align this imbalance of power so that no employer can exploit their employees and both parties can equally negotiate with each other about working conditions.
Some of the reasons why understanding the Labor Code is important, first is on salaries and wages. Understanding the Labor Code allows you to know what your minimum wage should be as an employee. Moreover, you learn the importance of timely and regular payment, especially when it comes to wages. No employer is allowed to exploit their workers. Therefore, if you are made to work overtime, you should be aware of your employer's obligation to pay appropriate compensation. Moreover, employers are also usually obligated to pay more when workers are required to work on holidays, weekends, and even at night. Second is on working hours. The Labor Code stresses the importance of reasonable working hours to ensure that each employee has a work-life balance. Workers are given paid annual leave along with a limit of daily or weekly maximum working hours. This ensures that employers do not take advantage of their workers by making them do unnecessary overtime work. Third is on protection. As an employee, your workplace may be responsible for certain aspects of your life. This includes family responsibilities such as paternity leave, parental leave,
and flex time options. The labor code also ensures that employees are not made to work in unsafe conditions. In case of health hazard, employers must inform their employee immediately. No information should be concealed. Labor laws also ensure that workers are protected and no laws are violated. Otherwise, there could be a grave consequences for the employer in terms of fine or imprisonment.
Lastly, on discrimination. The Labor Code ensures that workers can operate free of discrimination in the workplace. They monitor the employer-employee relationship so that no discrimination can be inflicted on the basis of gender, race, ethnicity, religion, or disability.
Define learner as an employee. Employer refers to a person who has been hired by a company to do a specific job. The employee is hired by the employer following a selection process that includes an application and an interview. This selection occurs after the employer determines that the applicant is the most qualified of their applicants for the job which they are hiring. An employee exchanges his or her skills, knowledge, experience, and contribution for monetary compensation from an employer. Each employee has a specific task to complete, which is frequently defined by a job description. A performance development planning process defines the employee's works and the organization's expectation from the employee's performance in responsible organizations. It should also assist employees in setting goals and tracking their progress. Furthermore, the performance management system should assist employees in developing ongoing skills and choosing a career path. Learners, on the other hand, are people who are learning and practicing the skills needed for a specific job. The tasks you expect of learners are heavily influenced by the apprenticeship and traineeship, as well as the workplace. The organization is responsible for understanding and implementing all of the learners' or trainees' training requirements. They will divide the learners' requirements into discrete workplace tasks that are appropriate for the workplace while also allowing the learners to advance in their training. As part of being a learner, learners must work towards achieving the competencies outlined in the training plan, complete the training and assessments outlined in the training plan, and update and produce the learner's record as needed. Thereafter, the learner should take the opportunity regularly to review specimens under expert guidance. Thank you.
Different types of employee under the rights of Philippine law. Number one is regular employees. A regular employee is similar to an indispensable cog in the corporate machine. Under the law, regular employees are those hired for activities which are necessary or desirable in the usual business of the employer. The second one is probationary employees. The category pertains to workers which place on a probationary status for 6 months, as is customary with the general practices. And the third one is term employees, also known as fixed-term work. Term employees are those who are hired for a specific period only. The arrival of the date in the contract automatically terminates him as an employee in the company. Next is project employees. The major distinction between the regular employees and project employees is that project employees are hired for only a specific project or undertaking. Okay, so the next one is seasonal employees. Seasonal employees are those hired for activities which are called to work from time to time. This may include a regular seasonal employees who are temporarily laid off or suspended during the off-season. But during Christmas holidays, for instance, when their services may be needed, they are hired by the company. And the last one is casual employees. These workers are hired for work or activities which are merely incidental to the business. It is not indispensable nor primarily related to the line of work of the employer. However, casual workers who have rendered at least 1 year service, whether continuous or not, are deemed to be regular employees with respect to the work for each day employed, for as long as the activities exist.
Good day, everyone. I am Jella Erica C. Avena, and I will discuss you about the three powers of employees. This is by Sunny Rothenberger from the website MentorWorks. So the first power is the legitimate power. So it says here that managers and executives are granted the right by their organization to request certain behaviors from others. So a manager may assign projects, distribute workloads, implement policies regarding sick days and lateness, and so on. So this legitimate power is one form of power that most employees are familiar with. So moving on, employees also have rights. They are granted legitimate power by federal and provincial laws to which their employers are accountable. For example, employees have the right to refuse to take on unsafe work or tolerate harassments. Both employers and the employees need to understand employees' access to legitimate power in order to create a safe and supportive workplace. The second power is the reward power. So when bosses determine employees' salaries or surprises their employees with a catered lunch, they are exercising reward power. So the legitimate power, as mentioned earlier, gives them control over the resources that can be used to reward employees. Forward-thinking organizations, though, will also give reward power to frontline workers through opportunities to provide feedback such as a 360-degree review. So this process can have a positive effect on manager-report relations. Third one is the coercive power. Coercive power is the ability to punish others, as when supervisors fire or threaten to fire their workers because of underperformances. Coercive power can also manifest between employees of similar rank, as when workers ostracize someone who is consistently late with their contributions, or withhold information from a colleague who has been too pushy. In this way, employees can have a profound effect on the ease or difficulty of a colleague's work life.
Employment contract. This employment agreement is a contract between an employer and employee here in the Philippines. It can be used to different types of employment such as probationary employment, regular employment, project employment, seasonal employment, fixed-term employment, or casual employment. This agreement sets all out the terms of agreement such as job duties, salary and benefits, work hours, confidentiality, and other key terms specific for each type of employment. Probationary employment, the period of probation and the standards upon which the employee competence and the qualification will be evaluated on. The maximum period of probation is 6 months, and the standards should be made known and explained to the employee at the time of engagement or signing of the agreement. Project employment, the description of the project and the date of completion of the project. Seasonal employment, the description of the season and the date of the end of the season. Fixed term employment, the starting date and the ending date of the employment. Casual employment, the description of the job which should be merely incidental to the main business of the employer, and the starting date and ending date of the casual employment which should be not for more than 1 year.
These are the most common employment contracts used in the Philippines. Fixed-term contract. In a fixed-term contract, the relationship between employee and employer is established for a defined period that is set in advance. This type of employment may also end when a specific task is completed. Full-time or part-time contract for an indefinite period. A part-time contract is similar to a full-time contract, the main difference being the agreed working hours. In the Philippines, part-time can only exceed for 4 to 6 hours. Agency staff or temporary employment contract. As an employer, you can hire temporary staff from an agency to meet an urgent need or transient increase in demand for your products or services, such as Christmas. This may also be called seasonal hiring. One of the examples would be the holiday seasons.
Labor laws, also known as employment laws, are those that mediate the relationship between workers, employing entities, trade unions, and the government. Collective labor law relates to the tripart relationship between employee, employer, and union. Individual labor laws concern employees' rights at work, also through the contract for work. Employment standards are social norms, in some cases also technical standards, for the minimum socially acceptable conditions under which employees or contractors are allowed to work. Hours of work. The normal hours work of an employee shall not exceed 8 hours a day. However, health personnel shall have a maximum of 40 hours a week. If made to work in excess of 40 hours, they are entitled to 30% additional pay. Meal period. As a general rule, every employer is required to give his employees, regardless of sex, not less than 1 hour or 60 minutes, time off for regular meals. Being time off, it is not compensable hours work. In this case, the employee is free to do anything he wants or she wants except to work. If he is required, however, to work while eating, he should be compensated therefore. Regular pay. Regular pay means the regular recurring pattern of pay for an employee while working his regular hours of work, including allowances, general holiday pay, premiums, but not include overtime. Base pay. Base pay is the initial salary paid to the employee, not including any benefits, bonuses, or raises. It is the rate of compensation of an employee receives in exchange for services. An employee's base pay can be expressed as an hour rate, or weekly, or monthly, or annual salary. Night differential. Night shift differential refers to the additional compensation of work performed from 10 o'clock in the evening to 6 o'clock in the morning. Employees will receive either an absolute increase in pay per hour or additional money calculated as percent of base pay in exchange for working graveyard shift hours.
Right to Service Incentive Leave, Article Number 5. 5-day service incentive leave would pay for employee who has rendered at least 1 year of service. Maternity leave benefits, or the RA 1161 or the SSS law. Maternity leave would pay for 60 days for normal delivery and 78 days for cesarean section delivery for every pregnant employee in the private sector, whether married or unmarried. A female employee should be an SSS member and must have paid at least 3 monthly contributions within 12-month period. Republic Act 8187 or the Paternity Leave Act of 1996. Every married male employee in the private and public sectors shall be entitled to a paternity leave for 7 days with full pay for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. The male employee applying for paternity leave shall notify his employer of the pregnancy of his legitimate spouse and the expected date of such delivery.
Without laws, we would lose these 3 benefits. People who have no incentive to follow group behavior. We would have no accepted authority who can resolve issues. And there will be no means to illegally and just punish people. Let's explore this further. When we have rules for behavior,
we necessarily have agreed upon standards to reference. That is, when a conflict arises, we can definitely say, in most cases, who was right and who was wrong. Thank you.